Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On June 23rd, the court decided Vega versus Tekoh, a case which concerned whether an un-mirandized statement against a defendant in a criminal proceeding violates the Fifth Amendment and might support a Section 1983 claim against the officer who obtained the statement. Joining today to discuss the court's decision is Misha Tseyltin, partner at Troutman Pepper and leader of the firm's National Appellate and Supreme Court practice group. Mr. Tseyltin, we're grateful to have you.
Thank you so much, and thank you for the Federal Society for putting on this series of podcasts. As was just mentioned, the fundamental question in this case is when a suspect proves that his or her rights have been violated as articulated in the Miranda decision, whether the suspect is limited to just having that confession obtained in violation of Miranda suppressed, or whether, in addition, the suspect can sue the police officer for violating the rights secured in Miranda. And by the rights secured in Miranda, I mean the U.S. Supreme Court's decision in Miranda saying that before subjecting a suspect to custodial interrogation, the police officer must read the suspect a series of rights that the suspect has in order to, in the Supreme Court's telling in Miranda, protect the constitutional right against self-incrimination found in the Fifth Amendment to the United States Constitution. In this particular case, the defendant claimed that he had been subjected to custodial interrogation by a police officer without receiving Miranda warnings. He had been tried in state court based upon a confession that he had claimed to have given after being questioned in this way by a police officer, and he was in fact acquitted in state court of the underlying charges. He then brought a lawsuit in federal court under Section 1983, which gives any citizen a cause of action for the deprivation of their constitutional or other federal rights, and the jury found in his favor. Thereafter, it was an appeal to the Ninth Circuit, which affirmed the jury verdict, and then the case went to the U.S. Supreme Court, where the U.S. Supreme Court had to decide for the first time whether a plaintiff could, in fact, bring a 1983 claim for violating the rights established in Miranda. In the Vega decision, the U.S. Supreme Court, in an opinion written by Justice Alito on behalf of Chief Justice Roberts, Justice Thomas, Justice Gorsuch, Justice Kavanaugh, and Justice Barrett, ruled that, in fact, the plaintiff here, who had been the defendant in the criminal action, could not recover under Section 1983. The court's reasoning tracked what one would expect from such a decision. That is to say, the court looked at Miranda itself, which said that the rule that it established was not mandated by the Constitution itself. That is to say, nothing in the Constitution requires these sorts of warnings. This was done as a prophylactic measure to protect the constitutional right against self-incrimination under the Fifth Amendment. And then the U.S. Supreme Court and to Justice Alito went through a series of decisions where the court had held that Miranda was just a prophylactic rule and had not applied it as it would if it were a full constitutional right. The court then discussed the most significant decision pointing the other way, which is Dickerson. In Dickerson, the U.S. Supreme Court had held that a federal statute, essentially not requiring Miranda, could not be enforced notwithstanding Miranda. And in that decision, written by then Chief Justice Rehnquist, the court had reasoned that while Miranda was not found in the Constitution itself, it was constitutionally grounded. This was a very oddly reasoned decision, but it is something that the U.S. Supreme Court had to grapple with. And what the court held in the present case is that, in fact, the Dickerson was limited. It was not constitutionalizing the Miranda decision. And because Miranda was not constitutionalized by Dickerson, a plaintiff could not bring a lawsuit under Section 1983 for recovery for deprivation of constitutional rights. There was a dissent in this case. It was written by Justice Kagan on behalf of Justice Breyer and Justice Sotomayor. Justice Kagan's decision relied very heavily on Dickerson, reasoning that Dickerson could not have reached the result that it did unless it was constitutionalizing Miranda. And as a result, Justice Kagan believed the same consequence should follow here. Justice Kagan also bemoaned the consequences for certain criminal defendants who have had their Miranda rights violated. Perhaps they were then wrongfully convicted based upon those violations, and they could then now no longer seek redress under Section 1983, and they would be left without any real remedies in Justice Kagan's telling. So what does this portend for the future? First, with regard to Miranda, I think it's clear that while the Supreme Court is not going to overturn Miranda, you gotta get your Miranda warnings, as you see in every crime procedural show. But the Supreme Court is not going to extend it in any way. It's going to keep it to its core, which is the protections of Miranda, and are what they are, and they can be used by a criminal defendant to suppress a un-Mirandized confession, and that's about it. And that's really where Miranda is going to stand, absent surprising developments. But more broadly, this case shows that the U.S. Supreme Court is not interested in fashioning additional remedies for constitutional violations that Congress itself did not fashion. This has been seen in some of the Supreme Court's decision in this term and in prior terms with regard to Bivens, which deals with federal agents, and here we see it dealing with state agents. I think the court is making clear that any remedial doctrines and new remedies for constitutional or other violations need to come from Congress, not from the court, as they often did come from the court during the war on courts' expansive foray into creating federal remedies. So that's the Vega decision, and I thank you all for listening.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.